My dear friends, I am Sethuram from Nivedita Academy. Today my topic is about the general principles of criminal law, which comes under criminal law. Mostly these kind of questions are asked in CLAT examination. There are basic principles. There are three kinds of basic principles which is governed by criminal law. One is a person who is convicted as a criminal only when that person has intention to do some kind of guilty, intention to do some kind of criminal activity. Such a person only can be treated as a criminal. He can be convicted by accident or emotional or some accidentally he does something. Such kind of activities you cannot take it as a criminal activity. He must have something in mind, already planned. He wanted to do some kind of criminal activity. Such kind of activity only can be considered as a criminal activity. Then another one thing, just because a police has filed an FIR and a person has given complaint and the police has filed an FIR, first information report, he cannot be considered to be a convict. There are a lot of other procedures are there, processes are there. Finally, he should be convicted. Till the time that person is only an accused, he cannot be said to be a convicted. So, a convicted person is a person, he is undoubtedly after trial proved that he is a criminal, he is a convict. Till the time he is not a convict, he is only an accused. Another one is the burden of proof. That is, suppose a person has made a crime, it is a police prosecution which has the burden of proof, it is the prosecution has the responsibility to prove the case. You cannot say that a person who has committed a crime and he is an accused, so he has to get himself away from that criminal proceedings like that. No, he has to prove, he has to show evidences, witness and all these things. No. It is the burden of proofs lies on the prosecution. The prosecution has to prove the case. The prosecution have to show all the evidences, proofs, everything. Till the time, you cannot blame that accused. That accused did not show, did not produce evidences to prove himself that he is not guilty, like that. The convict, the accused will always try to protect himself. And just like that, suppose he wants to be silent, a person wants to be silent. Yes, it is quite natural. A convict may not give all the evidences. Sometimes when the investigation going on, he may not give all the facts also. He will be silent. But once he is not able to, once he is refused to give his name or address, then that police officer can take it as it is a crime. It is a criminal act. That way one can find himself as a guilty. Otherwise, just because he is not giving any information, he is not giving any kind of evidences, he is not opening the mouth to prove the case, you cannot say that he is a crime like that. Okay. So these are the principles. And another one, double jeopardy. Double jeopardy means, suppose a person is accused for some kind of criminal activity and the trial was going on. Finally he is acquitted. Just because he is acquitted and you are not satisfied with the acquittal, you cannot give another one complaint and you can try the case. So according to the law, criminal law, it is double jeopardy. This cannot be allowed. A person cannot be convicted 2 times for the same crime. So one cannot be, another complaint cannot be filed also. But one can go for appeal, or any fresh evidence is there, you can continue the case in the same, giving appeals also. That way you can do, but you cannot make a fresh complaint again for the same crime. Okay, these are the basic principles of criminal law. Thank you.